For those of you who don't know, and many of you already do because I get a lot of repeat business, I'm John Foster. I'm a reference librarian upstairs. I have a PhD in history, which I mention not because hopefully what I say to you will garner your respect, because if it doesn't, the PhD in history in and of itself isn't going to help. So this is the third of 4 talks on justices of the Supreme Court. Previously, I did John Marshall and John Marshall Harlan. I'm past the John Marshall phase of the project now. Tonight's going to be Oliver Wendell Holmes Jr., and then on October 19th, I'm going to be doing Earl Warren. And you'll understand relatively soon, I think, why I picked those two. They might not seem like an obvious pairing, but they are. So Oliver Wendell Holmes is really one of the most remarkable figures in the history of American jurisprudence. And so what we're going to do for this evening's performance is I'm just going to talk a bit about his life, which was really remarkable, and then I'm going to talk about some of the cases that he was involved in. And we're not going to get too far into the legal weeds, but one thing we are going to talk about is a topic that has some very pronounced modern political implications, most of which I'm going to let you draw yourselves. But those of you who sort of follow what's gone on with the U.S. Supreme Court recently will probably have heard the term substantive due process lately. It's a term that's become a real issue of discussion. Again, it comes up periodically, and we'll get to the sort of first instance in a few minutes here. But with respect to the Dobbs case, I don't want to get too deeply into that, partly because my feeling is you don't necessarily want to hear my political views, and I don't want to express them necessarily in this format because this is my job. If you want to go over to BJ's and buy me a couple of drinks, I'm more than happy to tell you ad nauseum what I think about the price of tea in China and everything else. So Oliver Wendell Holmes was born in Boston, not in this house, but that's where his father, Oliver Wendell Holmes Sr., lived and where he grew up for the first part of his life. And he was born in 1841, and he was the son of a very well-known individual. So for a lot of his young life, he was referred to as Wendell because everybody knew who his dad was. His father, Oliver Wendell Holmes Sr., had trained as a physician, although he never practiced. Well, they did write a really interesting paper on puerperal fever, which is also often referred to as childbed fever. You don't hear about childbed fever very much anymore. And the reason is because doctors now wash their hands. This was actually before the germ theory came around, and basically what Oliver Wendell Holmes Sr. did was looked at a bunch of case histories and figured out, even without the germ theory, that what was happening was that obstetricians, while delivering babies, were not washing their hands in between, and you could track the cases between the... And independently of him, a Viennese doctor figured out that if the doctors between child deliveries washed their hands in, I think, chloroform and something else, that the incidence of childbed fever went down dramatically. But it was very controversial at the time. There were a lot of people who were like, no, this is just something that happens. So he was sort of well known for that. He was a professor of anatomy and physiology at Harvard Medical School starting in 1847. He was the dean of the Harvard Medical School starting in 1853. But he also had a lot of literary and cultural interest. He was great friends with Ralph Waldo Emerson and practically everyone else. And he founded the Atlantic Monthly in 1856. He invented the stereoscope. And he was renowned as one of the greatest talkers in sort of educated society, not one of the greatest conversationalists, because it was notoriously difficult to get a word in edgewise when you were hanging out with Oliver Wendell Holmes Sr. But he was also the one who coined the term the hub for Boston. Those of you who have spent any time, I spent 3 years living in Boston, will know that the Bostonians refer to Boston itself and the State House particularly originally as the hub of the solar system, later on as the hub of the universe, and that was a coinage of Oliver Wendell Holmes Sr. And this is Boston at a time, there's this sort of literary culture that goes on in Boston that sort of gets killed off by the Civil War, but I think it's almost best described by that kind of famous toast from that period that someone, I forget the exact source of it, but the toast was, "Dear old Boston, the home of the bean and the cod, where the Lowells talk only to Cabots and the Cabots talk only to God." Oliver Wendell Holmes Sr., you can see him here, and I think I was noticing this with his children. That's That's Oliver Wendell Holmes Jr. there. But it kind of looks as if somebody had just photoshopped his face onto the faces of three small children, especially his daughter, who really, I mean, if you had come along and told me that that was photoshopped, I would have believed it. Here he is with the Society for Medical Advancement. He wrote a famous series of books, the first of which was called The Autocrat at the Breakfast Table, and it was basically just sort of his kind of table talk. And this is a quote that I think is very sort of indicative of his approach to the world. I find the great thing in this world is not so much where we stand as in what direction we're moving. To reach the port of heaven, we must sail sometimes with the wind and sometimes against it, but we must sail and not drift nor lie at anchor. Imagine sitting around with a person who thought of life in those terms. Things were a bit different in the 1840s too, so. Oliver Wendell Holmes, at first, was educated in a school, the Dixwell House, that was founded by this fellow E.S. Dixwell. This is his daughter Fanny, who Oliver Wendell Holmes later married. Dixwell, okay, so there's a thing about photography in the 19th century. It took a long time for a picture to happen, which is why people tend to have these slightly grumpy looks on their face, because it's hard to smile for 20 minutes. And you don't want to be changing your facial expression because it'll mess up the picture. So props to Fanny here for maintaining a smile for however long this picture took to take. But Mr. Dixwell was apparently, I mean, much as he looks like a sort of a, you know, the kind of guy who would go for the switch, he really was a very nice guy and of a very moderate temperament. This is on Garden Street in Cambridge, which is a little bit north of where Harvard Yard is. He started there when he was 10, and he got the normal sort of Greek, Latin, a little bit of music, a little bit of mathematics, the kind of things you would teach your 10-year-old. This is the Boston State House. I believe this is from 1854. Now has sort of wings that go off to the side, and I think that's the Coolidge's house off to the side there, though I'm not 100% sure. This is Harvard Yard. It looks remarkably similar. My wife taught for 3 years at Harvard, and I spent a lot of time like hanging around there at the Widener Library, which is now there. Harvard Yard is the #1 tourist attraction in the Boston area. When I was working on my doctoral dissertation, it's a dangerous place. Widener Library is a dangerous place to be if you're like in late stage dissertation psychosis and you're interested in practically anything else than the giant project you have to finish, because you can put together enough stuff to work on any other project you might get interested in. So periodically I would come back to our apartment with these giant stacks of books, and my wife would be like, no, take those back to the library now. Don't. There's also off to the side here now a statue of John Harvard, and it's supposed to be good luck to rub his foot, so you can kind of see that the foot is always kind of shiny. I won't tell you what other rumors I've heard about that statue. Oliver Wendell Holmes started Harvard in 1857. At that time, Harvard was just the kind of thing that you did if you grew up in the area. It wasn't a terribly good school by the standards. Henry Adams, who was 3 years ahead of Oliver Wendell Holmes at Harvard, said that his judgment on Harvard was, it taught little, and that it taught ill. What was taught was religion, ethics, philosophy, history, literature, art, and science. And as Adams put it, it stood nearer the year 1 than the year 1900. But it was the kind of thing you did if you came from a certain kind of family in Boston. Oliver Wendell Holmes wrote for a number of the literary publications. He wrote an essay about Plato, a sort of critique of Plato's idealism that he gave to Ralph Waldo Emerson, which is the kind of thing that you also might do if you. I mean, he knew everybody because he was very hooked in. You know, he knew Ralph Waldo Emerson, who was older and very eminent. Emerson apparently read the essay and said, "Well, if you're going to strike at the king, you'd better kill him." But he was also friends with William James and Henry James, and actually, I think that William James was a competitor for Fanny Dixwell's affections, although he lost out. Oliver Wendell Holmes was a pretty convinced abolitionist, which was that was a big part of the coming apart of the sort of Boston of the 1850s. Upper crust Bostonians tended to be pro-union, which is to say, let's save the union, and if that means we have slavery, we'll be okay with that. There was a lot of anti-abolition sentiment among some lower class Bostons, particularly the Irish, sadly enough. I say this as a person of Irish descent. The Germans tended to be more abolitionist. There's a sort of incident that Oliver Wendell Holmes was involved with where he was part of the kind of guard for Wendell Phillips, the famous, some might say notorious abolitionist, when he was going to speak at Faneuil Hall and nearly caused a riot by doing so. Wendell Phillips, I can't, every time he comes up I have to mention that he thought that Abraham Lincoln was pretty weak on the subject of abolition, and Wendell Phillips once referred to Abraham Lincoln as a first-rate, second-rate man. Oliver Wendell Holmes joined the Civil War, or joined the Union Army when the Civil War started up, along with a lot of his classmates. They joined the 20th Massachusetts. First he joined another militia unit, and then a lot of them were enrolled in the 20th Massachusetts, which was actually, it was known as the Harvard Regiment, and it was actually a pretty hard-fighting regiment. Not that you would, I mean, much as that would probably come as a surprise, and much as it, I think, came as a surprise to many other people in the Union Army. This is his friend, Henry Livermore Abbott. They were best buds. Henry Livermore Abbott was an absolutely dedicated opponent of abolitionism. I mean, Henry Livermore Abbott thought that abolitionism was about the dumbest idea that had ever come up, but he thought that it was his duty to defend the country, and so he joined up with Oliver Wendell Holmes. As a matter of fact, there's a very funny letter that Abbott wrote to his father about what an idiot he thought Oliver Wendell Holmes' father was. Oliver Wendell Holmes' Sr. got to be very rah-rah for the war and for the cause of abolitionism once the war started, although he was not terribly pro-abolition before. Abbott thought that Oliver Wendell Holmes Sr. was just an idiot. But he really quite liked Oliver Wendell Holmes Jr. At one point they had to journey back from Boston down to where their regiment was down in Virginia somewhere, and they had these crazy adventures where they nearly got captured. And Oliver Wendell Holmes Jr. was wounded 3 times. He was shot through the chest sideways at Ball's Bluff. That took him about a year to recover from. Then he was shot through the neck at Antietam during the course of running away. As everybody, I mean, his unit was in retreats, but a bullet went through his neck. He survived that. And then he was shot in the foot at either Chancellorsville or the Wilderness. I've seen different stories on this, and the interesting thing being that Chancellorsville and the Wilderness happened at the same place. They just happened about 9 months apart. But so he was wounded 3 times. By the end of the 3rd time, he was really done with military service. This was 1864, and he wrote a letter home saying to his parents, while he was recovering, he was brevet promoted to colonel. And I mean, when you think about the fact that, you know, so this is 1864, so he's 23. But if you had showed, if you had survived 3 years in the Union Army, and if you had showed that you could lead men, he was actually offered the command, I believe, of the 54th Massachusetts, the black unit, and it went to Shaw, and his assistant, his adjutant, was another friend of Holmes's who was badly wounded in the attack on Battery Wagner where Shaw was killed. And by that time, he had gotten very jaundiced about the whole enterprise. And in the book, The Metaphysical Club, by Louis Menand, Menand says of Holmes's experience in the Civil War that it wasn't that it destroyed his idea, but it destroyed his faith in the idea of ideals. And you can kind of see that by the end of the war, he's really ready to get back to studying and get back to, you know, he really wants to live his life. He figures, I've done my bit, but I now want to get back to living a more normal kind of life. I'm going to sort of jump ahead only slightly here, because to sort of understand the profound effect that it did have on him, I'm going to read a section of a speech that he gave in Keene, New Hampshire on the 30th of May, 1884. It was at a Memorial Day celebration, in which he said, "Not long ago I heard a young man ask why people still keep up Memorial Day. And it set me thinking of the answer. Not the answer that you and I should give each other," and here he's speaking to a group of veterans. "Not the expression of those feelings that so long as you live will make this day sacred to memories of love and grief and heroic youth, but an answer which should command the assent of those who do not share our memories, and in which we of the North and our brethren of the South could join in perfect accord. So far as this last is concerned, To be sure, there is no trouble. The soldiers who were doing their best to kill one another felt less of personal hostility, I am very certain, than some who were not imperiled by their mutual endeavors. And as a matter of fact, he was very annoyed by people on the home front who were super rah-rah. You know, his feeling was, I'm out here because it's my duty to be out here. But, you know, if you want to be rah-rah about it, get out here and do it yourself. You know, I mean, he really didn't want to hear it from people in the rear echelons and further back at home. I have heard more than one of these, who have been gallant and distinguished officers on the Confederate side, say that they had no such feeling of, that is to say, of like strong personal animosity against the Northern soldiers. I know that I and those whom I knew best had not. We believed that it was most desirable that the North should win. We believed in the principle that the Union is indissoluble. We, or many of us at least, also believed that the conflict was inevitable and that slavery had lasted long enough. But we equally believed that those who stood against us held just as sacred conviction that were opposite of ours, and we respected them as every man with a heart must respect those who give all for their belief. The experience of battle soon taught us its lesson, even to those who came into the field more bitterly disposed. You could not stand up day after day in those indecisive contests where overwhelming victory was impossible because neither side would run as they ought when beaten, without getting at least something of the same brotherhood for the enemy that the North Pole of a magnet has for the South, each working in an opposite sense to the other, but each unable to get along without the other. As it was then, it is now. The soldiers of the war need no explanations. They can join in commemorating a soldier's death with feelings not different in kind whether he fell toward them or by their side. But Memorial Day may and ought to have a different meaning for those who do not share our memories. When men have instinctively agreed to celebrate an anniversary, it will be found that there is some thought of feeling behind it, which is too large to be dependent upon associations alone. That is to say, it's not just about like the ex-soldiers groups together. There has to be some other thing that carries it along. When we meet thus, we do honor to the dead in terms that must sometimes embrace the living. We do not deceive ourselves. We attribute no special merit to a man for having served when all were serving. We know that if the armies of the war did anything worth remembering, the credit belongs not mainly to the individuals who did it, but to average human nature. We also know very well that we cannot live in associations with the past alone, and we admit that if we would be worthy of the past, we must find new fields for action or thought and make for ourselves new careers. But nevertheless, the generation that carried on the war has been set apart by its experience. Through our great good fortune, in our youth, our hearts were touched with fire. It was given to us to learn at the outset that life is a profound and passionate thing. While we are permitted to scorn nothing but indifference and do not pretend to undervalue the worldly rewards of ambition, we have seen with our own eyes beyond and above the gold fields, the snowy heights of honor, and it is for us to bear the report to those who come after us. But above all, we have learned that whether a man accepts from fortune her spade and will look downward and dig, or from aspiration her axe and cord and will scale the ice, the one and only success which is his to command is to bring his work to his work a mighty heart. So basically, what he really wanted to convey was the Civil War wasn't about individual heroism, but it had this effect of, on all the people who experienced it, to sort of teach them what life was really about. You know, that it wasn't about this or that achievement per se. It was about how you approach the life that you get afterward. You know, for those who survived, what is it that you're going to bring to your life that you live afterward? What is it that you've learned? What is it? And it's that you have to be passionate in whatever you do. And Holmes, of course, brought that to everything that he did subsequently. At first he thought he might do philosophy, and he went and talked to Emerson about it. But Emerson said, well, it's a hard way of sort of getting by. And Holmes really thought that, decided that the law would be a kind of an interesting way to move forward. He thought it was much more interesting and kind of practical than chatter that his father and his father's friends were so fond of. He ended up being invited to give a series of lectures, the Lowell Lectures, which were turned into a book, The Common Law, It's really one of the sort of key texts of American legal history. The customs, beliefs, or needs of a primitive time establish a rule or a formula. In the course of centuries, the custom, belief, or necessity disappears, but the rule remains. And I like this too. This state interference is an evil where it cannot be shown to be a good. Holmes's legal philosophy, okay, so there's a number of approaches to law. There's kind of natural law, right, that says there's a law that's baked into the structure of the universe, and the law codes that we come up with should just reflect that. Then there's what's called legal positivism, and legal positivism says, well, there is no natural law. There's just the laws that we come up with, and what we have to do is come up with a legal code that's consistent. Holmes's view is what's referred to as legal realism. And it basically, he just says, what we have to do is kind of look at the law that's there and look at it as a bad man and sort of see what is it that the law, how would a bad man look at the law, and what is it that the law is meant to sort of prohibit. So, I mean, one sort of quote that's often bandied around is, this is from Edward Coke, who's a 17th century British legal theorist. Reason is the life of the law. No man out of his own private reason ought to be wiser than the law, which is the perfection of reason. So this is that sort of idea that the law is a sort of a consistent system. In the common law, Holmes, and in his Lowell lectures, Holmes said, the life of law has not been logic. It has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their own fellow men, have had a good deal more to do than the syllogism in determining rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it concerned only the axioms and corollaries of a book of mathematics. So the law isn't like math. It's not like you can sort of go through and just sort of calculate it in some abstract way. It has to respond to the situations in which one finds it. In order to know what is, we must know what has been and what tends to become. There's a lot of stuff that I'm not going to talk about in Oliver Wendell Holmes' life. I really recommend this book, Stephen Budiansky's Oliver Wendell Holmes, A Life in War, Law and Ideas. It's relatively recent. It's really well written. I read it in about 3 days. There's a whole bunch of stuff. Oliver Wendell Holmes was famous for liking to hang around with young women. And it caused some people to sort of speculate that he had been unfaithful to his wife. There's absolutely no evidence that he was. He was just a very convivial sort of guy. His wife also very much disliked the limelight and public social things. So periodically he would just go to England and hang out with people there, and she wouldn't. But he also was fond of kind of witty, or sort of wit and wisdom, you might say. And these are a few that have always sort of stuck to me. Taxes are what we pay for a civilized society. Sometimes we actually get it. A page of history is worth a volume of logic. That kind of gets back to what he was just saying. Like, if we want to understand what the law of the United States is, we can't just calculate it. We have to look at what has happened in the United States. And I like this one too. Even a dog distinguishes between being stumbled over and being kicked. In 1882, he became a professor at Harvard College. Up until that point, he had worked on admiralty law, which was a big thing if you were going to be a lawyer in Boston. That is, say, law of the sea. An endowed professorship had been sort of created for him. To a great extent, it was engineered by Louis Brandeis, who later would join him on the Supreme Court. Brandeis, by the way, they became great friends, although they were very different people. Brandeis is another fascinating character. The difference can be expressed, I think, in a lot of respects in the fact that Holmes liked to live nicely. He liked good food. He liked good wine. Brandeis, it was said that if you were going to go to dinner at his house, it was best to have a meal before you went. And that one of his clerks said that he was once served a slice of roast beef at Brandeis's house that was so thin he could see through it. But Brandeis was another. I may in the future do a talk on Brandeis. He's another absolutely fascinating character in American law and a really brilliant guy, and a guy that Holmes found a real working relationship with because they both had a sort of interesting commitment to free speech, which we'll get to in a little bit here. Holmes had basically just started this professorship when he was appointed to the Supreme Judicial Court of the state of Massachusetts. And there was a bunch of sort of shenanigans about how it happened. They wanted to appoint somebody else, and then it had to happen by 3 p.m. And then so he ended up taking this thing and renouncing this endowed professorship, which really annoyed a lot of people. As a matter of fact, Judge James Bradley Thayer, who later would be the judge in the notorious Sacco and Vanzetti trial, railed against Holmes and did so for several years afterwards. He thought it was kind of selfish and thoughtless that he would do this. But anyway, so in 1899 he gets appointed to the Supreme Judicial Court of Massachusetts. In 1902, he gets appointed to the Supreme Court of the United States by Theodore Roosevelt. Roosevelt liked him and managed to get him through the Senate, although partly because Roosevelt was very pro-imperialism, and Holmes had taken a kind of pro-imperial position in a series of cases referred to as the insular cases that he had ruled on in the Judicial Court of Massachusetts, which we needn't get into here, but the chairman of the Senate Judiciary Committee was bitterly anti-imperialism, and there was a big sort of there was some concern that Holmes would not be allowed onto the Supreme Court, but he finally managed to make it on. In those days, Supreme Court nominations were less politicized, although they're always a little politicized, but less politicized than they are today. But on December 4th, 1902, he was confirmed on the Supreme Court. One of his first big cases was a case called Northern Securities versus U.S. that was argued in 1903, I believe, and then judged in 1904. And it was a trust-busting case. That is to say, a fellow named James Jerome Hill, who was the president and largest stockholder of the Great Northern Railway, with the support of J.P. Morgan, had bought up a bunch of other railways and was unifying them, the Chicago, the Burlington, and Quincy. And Theodore Roosevelt was very much of the opinion that trusts were anti-competitive, and that pure bigness was a bad thing. And he had a point in the sense that the Burlington basically controlled a lot of the traffic in the Midwest. And if you did that, if you're in a kind of monopoly position like that, it allows you to charge higher prices because you're not getting competed against. If you ever wonder why, for instance, the prices are relatively high at a certain online retailer whose name begins with A, but which I won't mention. It's because they occupy not only in a lot of markets close to a monopolistic position, but they're also a monopsonist. That is to say, they're the only buyer for a lot of things. But they're not alone. That's a big issue in capitalism right now. But that's a different issue than this one. Anyway, the Supreme Court ruled in favor of the antitrust. So they forced Hill to break up the four railways and manage them separately. They were in fact unified in 1969 after people decided that trusts weren't such a big problem. That's a whole other can of worms, which we may get into in the Earl Warren talk. But Holmes dissented. And the reason why is not so much important. The fact that he did so was important. Roosevelt was really incensed. Roosevelt kind of liked him. And it pretty much permanently damaged his friendship with Roosevelt. Roosevelt, after that, didn't really trust him, didn't really like him in the same way that he had, didn't want to interact with him socially in the same way that he had. Because trust busting was one of Roosevelt's big, as a kind of progressive Republican, one of his big things was creating markets that actually worked to depress prices through appropriate competition. So now we're going to get into a few of the other crucial cases, and the big one, and the one that will have sort of most consequences, was from 1905. It was argued in 1905, and then I think the judgment came down in 1906. And this is Lochner versus New York. Lochner versus New York is so important that the court, for 30 years after that, was referred to as the Lochner Court. And the case basically went like this. The state of New York passed a law saying that bakery workers could not be compelled to work more than 60 hours in a week, and couldn't be forced to work, I think, more than 10 hours in a day. There were some other aspects to it. But it was basically, from the perspective of the New York State Legislature, a health and safety regulation. There was a baker, I think in Utica, somewhere out in the non-New York City part of New York, named Lochner, who wanted to have his bakers work longer. and he sued. There's a number of reasons why this case is interesting. Number one is that it establishes this principle of what has now come to be called substantive due process. And here's the thing to remember. So basically, the majority, and Holmes dissented, also John Marshall Harlan dissented, the majority argued that the agreement between the Bakers and Lochner was a free contract. So the Bakers had, if the Bakers wanted to work 60 hours a week or more than 10 hours a day, they were free to make a contract to do so. There's some problems with this. The number one problem being, where in the Constitution does it say that you get to do that? Where is freedom of contract mentioned in the U.S. Constitution? Spoiler alert, it is not. At no point does the U.S. Constitution say that you have freedom of contract. But the decision, the majority decision delivered by Justice Peckham, was that it was implicit in the due process clauses of the 5th and 14th Amendment. So the 5th and the 14th Amendment say that no one shall be deprived of life, liberty, or property without due process. And basically what he said was, this has to imply that freedom of contract is one of these things. Now, of course, there's another problem, which is that this whole thing, and this, was sort of pointed to by Holmes in his dissent. Well, I'll read Holmes's dissent. You can get to it, but and you can sort of see why. Holmes had two sort of big issues with this. One is Holmes basically thought that just because something was a bad idea doesn't mean that it's also ipso facto unconstitutional. And he thought that all other things being equal, the decisions of the legislature should be given weight because that's the decisions of the majority, right? So unless the legislature comes down with something which is obviously unconstitutional, that they should sort of be given the benefit of the doubt. That was one of his sort of general propositions, so to speak. The Peckham's decision said basically, well, working in a bakery, it's not like working in a mine. And here he was referring to an earlier decision that had happened in Utah, Holden versus Hardy from 1898. And this is what Holden versus Hardy said, and this is worth thinking about. A constitution is not intended to embody a particular economic theory, whether of paternalism and the organic relation of the citizen of the state, or of laissez-faire. It is made for the people of fundamentally differing views, and the accident of our finding certain opinions natural or familiar or novel or even shocking ought not to conclude our judgment upon the question of whether statutes embodying them conflict with the Constitution. I think that the word liberty in the 14th Amendment is perverted when held to prevent the natural outcome of a dominant opinion, unless it can be said that the rational and fair man necessarily... Oh my gosh. This is the end of Holmes and Lochner. Sorry, but this is good because this is really what he has to say. I want to actually get to the first thing that he says, and then I'll clarify. Sorry for getting out of order. This case is decided upon an economic theory which a large part of the country does not entertain. And the economic theory he's talking about is like pure laissez-faire capitalism. As far as he was concerned, like a lot of people in the country didn't hold that view. If it were a question of whether I agreed with that theory, I should desire to study it further, and long before making up my mind, but I do not conceive that to be my duty, because I strongly believe that my agreement or disagreement has nothing to do with the right of the majority to embody their opinions in law. The liberty of the citizen to do as he likes, so long as he does not interfere with the liberty of others to do the same, which has been a shibboleth for some time, for some well-known writers, is interfered with by the school laws, by the post office, by every state or municipal institution which takes his money for purposes thought desirable, whether he likes it or not. The 14th Amendment does not enact Mr. Herbert Spencer's social statistics. So Herbert Spencer had a lot of complicated ideas, but one of them basically was that human beings... Herbert Spencer was the sort of originator of social Darwinism as an idea, the idea that Darwin's ideas about survival of the fittest could be applied to society. This would have shocked Darwin. It did shock Darwin, who firmly disagreed. But anyway, Holmes is basically saying what's really going on here is the legislature has made a kind of decision about using what's called its police power to make these health and safety regulations, which is kind of a version of a lot of different things that it does through taxation. you don't have complete freedom to dispose of your property. Like, the government gets to tax some of it to keep society from falling apart, and that was kind of his view. But the piece of this from Holden versus Hardy, which I will not dig up now just to avoid wasting your time, is that in Holden versus Hardy, which was a similar case that had happened in 1898 in Utah, where minors, the state had made a law saying that minors could only, limiting the conditions or regulating the conditions under which people could mine. The Holden versus Hardy had said, well, and the mine owners had sued, and basically what the outcome of that was A, mining is dangerous for you, but B, the miners and the mine owners were not, this wasn't a free agreement between people in equal status. So if I own a mine and I want you to work on it, it's not like you're sitting around thinking, God, maybe I really do want to work, 70 hours this week. Basically, the way it works, and anybody who's gone looking for a job will know, the guy offering the job is in the advantageous position because he's got it and you need it. And he basically, I've never gone to a job to have and had the person say, well, you could work 30 hours or 40 hours or 50 hours or 60 hours. My prospective boss has come to me and said, you will work this period of time. You will also dress the following way. So it's basically what Holmes and what Holden also acknowledges is that there is this sort of inequality. But interestingly enough, this decision in Lochner basically essentially becomes the law of the land as the Supreme Court systematically over the course of the 19-teens, 20s, and into the early 30s, systematically strikes down all sorts of worker protection legislation on the basis of this substantive due process, on the basis of a freedom of contract idea that's based on this substantive due process. And it's not until Parrish versus West Coast Hotels in 1937 when the Supreme Court finally acknowledges, as a matter of fact, Holden is actually mentioned in Parrish versus West Coast Hotels. Parrish versus West Coast Hotels was about a woman in Washington State Washington State had made a minimum wage for hotel workers, and she sued because the hotel she was working for wasn't paying that rate, and she sued to recover the difference, and won. And the Supreme Court basically, at that point, acknowledged, hey, the hotel is in one position, she's in another, and the state has an interest in protecting her. Now, Parrish is interesting too because part of it was, well, she's a woman, right? So the state has a kind of has an interest in protecting women because we need women to keep making babies, et cetera, et cetera. But so think about this as we go on. When you think about substantive due process, it's heavily debated right now, and the Dobbs decision, which I am just not going to get into for right now for reasons which I think are obvious, is predicated on certain people on the court, particularly Samuel Alito, Neil Gorsuch, Amy Coney Barrett sort of, but for different reasons, thinking that, and Antonin Scalia was a big partisan of this, thinking that substantive due process just isn't a thing. So substantive due process goes away after 1937, comes back under the Warren Court, where you get decisions like Griswold v. Connecticut, which legalizes birth control between married couples, and Loving v. Virginia, which Loving v. Virginia is actually primarily adjudicated on the Equal Protection Clause, but they also mention substantive due process. This is an interesting thing, and I will just mention this and then I'll get back to our topic. Loving v. Virginia basically said that states couldn't make laws forbidding interracial marriage. And one of the big opponents of substantive due process is Clarence Thomas, who is in an interracial marriage. And it always strikes me as kind of funny. If I was him, I think I'd be a little more cautious about it. But that's beside the point is that there's a whole lot of things that we now take for granted that are based on substantive due process, which, like privacy, once again, go through the Constitution and see where it says you have a right to privacy. So this is Otis v. Parker. This was slightly earlier. This is one, I think I was mentioning to some of you in an earlier talk. Otis v. Parker was a law that was instituted in California saying that you couldn't buy stocks on the margin. Holmes' position on this was basically well, I think this is a dumb law, but just because it's a stupid idea doesn't mean that it's unconstitutional. While the courts must exercise a judgment of their own, by no means is true that every law is void which may seem to the judges who pass upon it excessive, unsuited to its ostensible end, or based upon conceptions of morality with which they disagree. So, once again he's saying, it's okay if people have bad ideas. It's okay if they embody them in law. Just as long as they don't obviously violate the Constitution, we should give the benefit of the doubt to the legislature because the legislature is speaking for the majority. This is Lochner, that's Lochner's bakery. Substantive due process, and I just thought I would sort of point this out. This is the Fifth Amendment, and I just highlighted no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment, where they added on, and this is key, right, because this is 1868, and they're making the point that there's a particular group that's likely to be trying to deprive people of life, liberty, or property without due process of law. Nor shall any state. That's a key thing there. And in fact, by the way, it wasn't until the early 1930s that it was actually conceded that the Bill of Rights applied to state laws. This is what's called incorporation. For a long time, the view was that the Bill of Rights only applied to laws that the federal government made. But here, and this is another sort of thing, the Ninth Amendment is one of the most oft-forgotten amendments in the whole Bill of Rights, but it's I think, an interesting one. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What are these rights? It doesn't say. And there's a very long debate, which continues to this day, about what rights might actually be retained by the people that are not enumerated in the Constitution. Some people say, there's some who say, well, what it means is there's a whole bunch of sort of generally accepted rights, but this is I'm going to stop there because the weeds are going to get here soon. But just before we get back to sort of the immediate topic that we're discussing, there's a theory which has gotten popular since the 1980s, which is often referred to as originalism, the idea of which is, when in doubt, look back at what the framers thought. That was sort of what Robert Bork's idea was. The problem with that is, it's unclear exactly who the framers were. Jefferson wasn't at the Constitutional Convention of 1787 for a start. It's unclear in a lot of cases what they meant. They didn't keep notes. Madison kept some notes at the Constitutional Convention. Also, when was the last witch trial in the United States? Does anyone know? What year was the last witch trial? 1878. So if you're thinking that what we want to do is go back to how people thought about things in the 1770s, just remember that people thought some pretty weird things back in the 1770s. Now, the last person who was executed for witchcraft was in the 1690s. Let's just be clear about that. But people did have some ideas that we as modern people would view as not. And just think about the things that aren't mentioned in the Constitution. The right to educate your children. The right to move between states. There's a whole bunch of things. And so there's a debate that's going on now to this day about, do we interpret the Constitution as a kind of liberty, preserving document, or do we interpret the Constitution as being the expression of what people thought in the 1770s? And Holmes had things to say about that, for sure. This I just thought I would add for the purposes of repetition. A constitution, this is John Marshall, the fourth Chief Justice, a constitution to contain an accurate detail of all the subdivisions of which its great powers will admit, and of all the means by which they may be carried into execution, would partake of the prolixity of a legal code and could scarcely be embraced by the human mind. So once again, this is John Marshall saying, just because something isn't explicitly mentioned in the Constitution doesn't mean that it doesn't fly, because the Constitution isn't supposed to mention every single thing that the government could legitimately do. So one of Oliver Wendell Holmes' big influences on the court was his support for freedom of speech. So the first big case, this is Schenck versus U.S. from 1919. Schenck was a member of a socialist group, and he was distributing this pamphlet to soldiers who had been drafted, people who had been drafted. This is during the First World War. And basically saying, the draft is illegal, the draft is a violation of the Constitution, the war has nothing to do with us. This is a great Oliver Wendell Holmes line that you'll hear repeated by people. The most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic, right? So the First Amendment protects free speech, but the protection on free speech is not unlimited. And this is something we should think about all the constitutional amendments, about all the things in the Bill of Rights. So for instance, freedom of religion, right? The state shall make no law establishing religion, right? But if your religion involves eating people, the state's not going to let you do that, right? So there are some limits, and the point is to sort of decide what reasonable people think that the limits are. Gitlow is another one of these cases, and it's really fascinating because Gitlow is an anarchist who's publishing an anarchist newspaper, and he runs afoul of the sedition laws. This is in the sort of period after the Bolshevik Revolution when people are really frightened by communism. And so Gitlow is interesting, number one, because Gitlow is the case that finally establishes that the Bill of Rights applies to all things, that the Bill of Rights applies to state laws too, incorporation. Holmes basically dissented in this. I mean, Gitlow ended up doing a long stretch in Sing Sing. But Holmes dissented, and in short, his comment was, eloquence may set fire to reason, but whatever may be thought of the redundant discourse before us, it had no chance of starting a present conflagration. Translation, this guy's writing is so boring that there's no chance that anybody would read this and be like, I'm definitely going to start a proletarian revolution right now. And that's his point, right? So this is why free speech is important, and we need to think seriously about whether what kind of danger is involved. This is another sort of part from his decision. We may admit, in many places and in ordinary times, the defendants, in saying all that was said in the circular, would have been within their constitutional rights. But the character of every act depends upon, this is Schenck. Now, then I'm going to get to Gitlow. Character of every act depends upon the circumstances in which it is done. The most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic. It does not even protect a man from injunction against uttering words that may have all the effect of force. The question in every case is whether the words are used in such a circumstance and are of such a nature as to create a clear and present danger. That's what's often referred to as the Schenck standard. So, does the speech create a clear and present danger that they will bring about substantive evils, right? So, I could say, fire right now, but you people all know, like you're looking at me, you know that I'm not saying there's a fire. If there was a fire, I would respond in a much different way, and probably like the alarm would be going off, although that door wouldn't set it off. But, so you have to look at the context, right? Whereas if I'm sitting in the Atlas Cinemas across there, and I start shouting fire in the middle of the Barbie movie, that's a different, I may have some reasonable ground for wanting to get people out of that cinema unrelated to, whether there's a fire or not. But the context is important. So if I'm in a crowded theater and I shout fire, my free speech rights are limited by the clear and present danger that my shouting fire will cause. I love this decision too. I mean, I love this. I'm sorry that your writing in your newspaper is so boring and so turgid that it couldn't possibly meet the Schenck standard. The Schenck standard hung around until the 1960s, when it was replaced by Brandenburg v. Ohio is the name of the case, and it was about a guy down in southern Ohio who was the grand dragon in the local clan. And the question was, he had said some kind of clan type things, and the state had basically, the state of Ohio had passed a law. I'm trying to remember the exact. I'll talk about it more in the Warren Court thing because it comes up there. But the at that point they adopted a kind of a slightly looser standard about whether speech was likely to cause an immediate
danger.
So why does it have to be an immediate danger?
Uh,
You can see how things, like a few years ago, no one would pay any attention to.
Right.
Now today, all of a sudden you got a whole bunch of militia guys doing it.
Well, A, because it's hard to know, we can't really tell the future, but B, because Holmes makes this point. I wonder if I have it. I meant it. I have an answer to your question. This is from another Holmes dissent, Abrams v. U.S. from 1919. This is another one of these basic cases. Persecution for the expression of opinions seems to me perfectly logical. If you have no doubt of your premises or your power and you want a certain result with all your heart, you naturally express your wishes in law to sweep away all opposition. To allow opposition by speech seems to indicate that you think the speech is impotent, as when a man says that he has squared a circle, or that you do not care wholeheartedly for the result, or that you doubt your power or your premises. But when men have realized that time has upset many fighting faiths, they come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade and ideas. So this is another thing. So the best way for American society to embody itself is this free trade and ideas, this free market and ideas. And that's the sort of, as far as Holmes is concerned, the fundamental basis of the American system. And once again, it's okay to have dumb ideas. He often referred to socialism as drool. Like he really thought it was a stupid idea. But he also thought that people might decide that that was the kind of government they wanted. And if they did, and if a majority of them did, that was okay. Now, your point is a good one, right? Because we've now come to a situation where we don't really have a free market and ideas. What we have is a kind of like several kind of captive silos of ideas, some of which are, I point out to you that I noticed in the paper the other day that the U.S. Congress is literally having hearings about UFOs. And we have really come to a pass in this country when the U.S. Congress is discussing. Maybe there are, but I haven't heard anything that would make me think that necessarily the Congress needed to be debating that. Opinions may vary. So this is Missouri v. Holland from 1924, yet another Holmes decision. When we are dealing with words that also are a constituent act, like the Constitution of the United States, we must realize that they have called into life a being, the development of which could not have been foreseen completely by the most gifted of its begetters. It was enough for them to realize or hope that they had created an organism. It has taken a century, and it has cost successors much sweat and blood to prove that they created a nation. The case before us must be considered in the light of our whole experience, and not merely in that of what was said 100 years ago. So once again, Holmes is basically saying the Constitution has to be a living document. And the way we organize our laws has to acknowledge the fact that things aren't the same as they were in the 1770s. I have one more thing to say about Holmes, but I'm going to read this passage to you from West Coast Hotels. This is from 1937. So after Holmes is off the court and after he died in 1935. The principle which must control our decision is not in doubt. The constitutional provision invoked is the Due Process Clause of the 14th Amendment governing the states, mind you, as the Due Process Clause invoked in the Adkins case governed Congress. In each case, the violation alleged by those attacking minimum wage regulation for women is deprivation of freedom of contract. Once again, the Lochner standard. What is this freedom? The Constitution does not speak of freedom of contract. Once again. So when we're sitting around saying, well, let's be literalists, right? Let's look at the Constitution and whatever is that, there's a lot of things that are not in the Constitution that you would want in a civilized society, probably. Irrespective of which side of the political spectrum you end up on. This is the crazy thing about American law. It's like a tube of toothpaste.
like if you crush down on one part, some other part comes out. So irrespective of whether you're a conservative or a liberal, if you get rid of one thing that you don't like, you end up getting rid of or permitting something else that you don't like. And it's true of both sides of the spectrum. It's really one of the peculiarities of law generally, as I say as an outsider. The Constitution does not speak of freedom of contract. It speaks of the liberty and prohibits the deprivation of liberty without due process of law. In prohibiting that deprivation, the Constitution does not recognize an absolute and uncontrollable liberty. Liberty in each of its phases has its history and its connotation, but the liberty safeguarded is liberty in a social organization which requires the protection of law against the evils which menace the health, safety, morals, and welfare of the people. Liberty under the Constitution is thus necessarily subject to the restraints of due process and the regulation which is reasonable in relation to its subject and is adopted in the interests of the community is due process. So they keep mentioning morals, by the way. I think this is really interesting. The idea is like if you work people too hard, they'll become immoral. I can tell you from having a job that took up 12 hours of my day all the time, I really had very little time for immorality and very little energy with which to pursue any kind of notional immorality that I might have been interested in. Oliver Wendell Holmes served on the Supreme Court until he was 90. Finally, when his colleagues had determined that he was no longer sort of fully up to it, the Chief Justice of the Supreme Court went to him in tears and said, look, I think it's time to go. And Oliver Wendell Holmes said, yeah, you're right, it is. And he spent a few years in a very pleasant retirement. He had a house in Washington, D.C., and he had many friends. He had a very active social life. Early in his presidency, Franklin Delano Roosevelt and Eleanor came over to sort of have an official visit with him and chatted with him. It was very pleasant. He died, apparently as natural causes, as far as I know, or pneumonia, excuse me, in March of 1935. But he's really a remarkable guy, and for three reasons that I'm going to finish up by talking about. One is, he's an expression of a kind of American culture that disappeared with the Civil War. He's not an exact, he wouldn't have really fit into that Boston of his father, of the Ralph Waldo Emersons and the William Jameses and the Transcendentalists. Because he had a more sort of pragmatic idea of how the world was supposed to be organized, and was much less sort of poetical than they were. He had a much more sort of historically informed idea. And his idea of America was, let's look at what the history of America has been. Let's look at where we are now and how we got there. And let's try and organize ourselves in a way that makes sense to that. Even if it's a bad idea sometimes. I mean, this is, I think one of the enduring ideas of his jurisprudence. It's okay to have bad ideas. That's the great thing about the American system. We keep trying ideas. Sometimes we find a good one. Sometimes we find a bad one. But the way our system is organized is about process. That we can have a reasonable discussion, hopefully, among ourselves, and in which if you have a bad idea, the way to counter that bad idea is by a reasonable argument, not by calling someone a jerk or threatening to beat their skull in. And this is one of those things that, nota bene, both sides of the political spectrum right now. Like the way, the problem with our polarization right now is the unwillingness to engage the American system in the way that it's meant to be engaged. What it's meant to have is a kind of give and take instead of trying to sort of capture parts of it for certain kinds of ideas. But I think the most interesting thing about Holmes is his willingness to embrace ideas that were not popular. So many of his interesting ideas come up in these dissents. Oh my gosh, I have to mention this. I almost got out of here without talking about this. Oh God. Buck versus Bell. This is, I'm sad I have to, I'm going to mention this now that I unfortunately am. Buck versus Bell was a case in West Virginia about this woman, Carrie Buck, who the state wanted to sterilize.
because her mother had had some sort of mental illness, and so had her grandmother, I believe. Basically, they did. And Holmes uttered this incredibly horrible line, 3 generations of imbeciles are enough, grossly violating her human rights. And the irony was that he had not been informed that she was actually a very good student. We have her school records. She was not in any way deficient mentally or psychologically. So this was one of those things where I have to say a sad thing about a guy I really respect. This was a bad decision, and one that never should have been made. But maybe it's worth, taking that on board, because if you're going to look at somebody important, you have to look at the whole person. And the fact that he made this bad decision, the fact that he wrote this bad decision, doesn't detract from the value of his jurisprudence. It just means that in this case, he's fallible like all human beings are, and probably, I think if he'd been better informed, he might have decided differently. God, I wish I had taken that slide up because it's so sad.
I was going to bring it up.
Right, yes, thank you. Well, but, once again, all of these talks, we're going to find something about the person that's problematic. I mean, John Marshall, brilliant guy, lots of important decisions. McCulloch v. Maryland, I think one of the most important decisions in the history of the United States, ruled against black and enslaved people almost without exception. And in a number of cases he did so even though the law was black and white the other direction. John Marshall Harlan, in his dissent in, is it Plessy, where he's like, of course the white race is superior. That's some sort of unfortunate things. But what we have to do is look at the fullness of the person and how do these things reflect on their jurisprudence. I don't think that Buck versus Bell's wrongness detracts from the larger quality of Holmes's jurisprudence and the important things that he added to American law. Yeah.
Yeah, I was listening to a podcast this morning, and they brought this up, and part of this decision, I think, was based on another 1902 decision regarding the rights of the states to go ahead and enforce health.
Right.
Certain health.
Right. You're exactly right. You're exactly right. And I'm trying to remember the name of it. I was reading it too. And that's exact. And it's consonant with his decision with his dissent in Lochner, that the legislature can make these social hygiene laws. The unfortunate thing is that the Nazis picked that stuff up and ran with it. The American, in 1932, there was something like 20 some states that would allow that. And the Nazis pointed to that when they passed their racial hygiene laws. They were like, look, as a matter of fact, there's a piece of Nazi signage that says, we're not alone. And then it shows the flags of all the countries that have racial, sterilization, racial hygiene laws. So, but you're absolutely right, and that's a great point to make, because it is consonant with, I think, a really valuable theme in his jurisprudence just happened in that particular case, that if he had been better informed, this is, hopefully he would have come to a decision that would have defended Carrie Buck's human rights. Okay, so that's mostly all I have to say, except to say that when I talk about Earl Warren in October, the topic of substantive due process is going to come back with a vengeance. And it's an interesting topic, and I am going to do my level best, as I always do, to not preach politics from the lectern. So once again, my political views can be had for the price of 3 pints at a bar of your choice. But anyway, thank you so much for your time. Inflation.